But they're entertaining. And so
what is this
make
about?
It's about how he
to
bungled
save
admitting that
text
picture.
messages.
I think
I haven't figured that out, and I haven't.
Oh,
I have a lot of things that I'm doing, so that's a low priority for me to figure out how to save a text message. And I don't want to leave them on my phone forever. I want it off so that it's clean. So when I look at it, I'm looking just at the fresh stuff. So then I do a screenshot of it and I email it to myself to save it. But I found, to my distress, some of them are pretty long and they show up in my email.
Okay,
Like
I see where he's going.
Like a little ribbon down the center of the page.
when
Some
I
are even
zoom it in,
smaller
I
than
can't
this.
see shit.
Well, and it's just a blur.
yes,
Oh my god!
We were talking the other day, one of you two,
it's
about
magnifying glass.
just like a cell phone where you can expand a picture and make it bigger. Well, it's not making it any bigger. It's making it bigger, but it's nothing but a blur. That was my concern that I wanted to ask Mr. Armstrong about, and I guess I should have, for him to explain it better for me as to how that can be reliable. Because it isn't reliable for me in getting my messages on my phone. Now, maybe if I reset it to a site, I could explode it again or decrease its size again, and I don't know. But here you've got a picture, which I have to tell you, I think it's very blurry.
I agree. And the picture is one of 5 or 6 pieces of evidence.
What are the other 4?
I know the defense wants to focus on this picture, but the picture is only one. We have 3 videos, one unedited, completely untouched drone video, which I think is where you see it clearest.
What?
And then we have one that is zoomed in, and we have one that is slowed down. I believe the clearest shot is actually the original drone video.
Where?
So we can present that evidence, and they can rebut it. I think you're taking the picture wrong on your phone. I'm not tech support.
Pardon me?
I think you're taking the picture wrong on your phone.
Is that it?
I think so.
I'm not surprised.
But these things are in evidence.
And they shouldn't
He
be.
actually is.
You watched it on the
For
screen
the
yesterday,
analogy,
whether
he's
you
taking the
form your
picture
opinion or
exactly
not.
right.
And that was
Well, my
probably
opinion is not what counts, except to the extent that if there's no
Oh
I'm proud to be American.
God,
no
There we go. There's a new meme.
Rump
What's
judge.
that say?
if it's just totally unclear, then I certainly can't give a provocation instruction based upon a picture that I can't
This
make
is really
anything out of.
important.
I agree with you. The ultimate determination of
critical.
what it shows is for the jury.
This is everything.
This
It
is
is
their
not
only
You have
hope
to
to
be over
thread
the
that needle.
threshold.
It's absolutely not based on the picture. It is based on the drone video and the testimony. And this was testimony elicited, if
If
not
the
by
state
the
loses
defense,
a provocation
then in
instruction,
response to
Kyle
their
has to
questioning,
walk on self-defense.
Detective Antaramian testified
They
that
should
he
just go
reviewed
home.
it and saw it, and that was a common question to many people in this case. The photo is like the 5th or 6th most important piece of evidence.
What
the
are the
most
other
important
4?
piece of evidence on this point is the drone video itself, and that is unedited.
Show it.
There are some
Show
edited
us.
copies
Show us
as well
right
that
now.
are helpful.
What the hell are you
But
talking about?
to focus on this photograph, that was almost an afterthought simply because we didn't get it till the day before, and we figured it may be helpful at some point. The photograph is, we may not even show that to the jury. It is based on the drone video and the testimony of Detective Antaramian. It is in the record. We have evidence of provocation. I can't fathom why, if there is evidence in there of provocation, which we have clearly done, why we cannot argue
Clearly,
it,
it's
why we
blurry.
cannot get that instruction. The defense is free to completely call it whatever they want and to attack it. But that
Did
is
you
why
say
we have
it clearly?
trials.
I haven't seen it clearly. Okay.
I have.
Oh,
You have.
Oh.
Why don't you just sit in the jury box
They're
also?
arguing
Cra-
for something
rein in
saying we've
Kraus.
been on notice from the beginning.
Him snapping at
And
the
if they
judge is
wanted
so
to put on the
stupid.
evidence to prove up provocation, all they had to do was call Mr. Zeminski or Mrs.
Thank you.
Zeminski
Oh.
Yes,
to
there we go.
rebut the
Yes.
story that we
Yeah,
have.
maybe they'll
They
come up
didn't
and
put
close
him
argument.
on because Detective Antaramian, Detective Howard both know he's a liar. And they're building their whole prosecution on that without putting him on.
well, they don't have to call a particular witness.
But they don't have the provocation. And, we had all these little things going on yesterday, and I went back to my office, and the whole essence of the problem came down to these two facts in the testimony. Examiner Armstrong took 20 hours to manipulate that photograph to get that blurry mess up on the screen. We had our expert do it right in front of the jury in seconds, and it showed what it was. And that's where the hocus pocus and adding the pixels and all the other garbage comes in, and that's what they're building their prosecution on.
Again, we're focusing on a picture that is again, we're focusing on a picture that I've said repeatedly now is the least.
Get rid of it.
Uh,
Get rid of it.
The
Get rid
least.
of it.
Well, show me the best
Convincing.
one.
Well, then if it's
Show
me the
next one.
Next.
This man is talking himself into a trap.
Yesterday, before Mr. Armstrong was allowed to testify in rebuttal, we went over this about
Bigger's trying to
whether or
help
not
now.
the methods he was using were appropriate, and we showed you. You walked up to the 4K
Yeah.
TV, and we showed you exactly what it is we're talking
And
about.
I'm not even going to tell you what I thought when I saw it.
This is not a court trial. You're not the finder of fact. We have facts.
I know it, and that's why I let it go to the jury.
We have.
That's what we're asking.
That's what we're asking: is that the jury be allowed to consider the state's evidence? Is essentially what we're asking.
I don't think, Your Honor, you would have allowed Mr. Armstrong to testify yesterday. I don't think you would have allowed him to testify in rebuttal unless you had made some determination that there was some basis for this.
Tell the
What I
judge
made
he
a
was thinking.
determination was that I thought the jury should make the decision.
And that's all we're asking.
So that's your best picture, the one I saw over there?
No.
Where's the best picture, please?
Please,
Ooh.
please.
We'll show up at the finder of fact.
You're asking me to give an instruction. I want to see the best picture.
Oh, he's getting upset.
It's the.
We
'cause
need
he-
to get Mr.
We'll
Stewart.
Caught
show
them
it
in
to the
bullshit.
finder
You need
of
the-
fact.
You need it on the big TVs.
You need it on the big TV?
Get the big TV.
Get the big
Just
TV.
or reject the instruction. He doesn't want to show you. Why didn't he want to show you? Reject the instruction.
Get the big TV.
They're trying to gaslight the judge.
Oh, and
Yeah.
he sees it.
I mean, there's enough gas.
That's why he's
going
taking
in
a
that
pause
place.
right now. He's calming himself down.
Nick, if somebody lit a match in there, the whole building would blow up. All the gaslighting going on by the prosecution.
Yeah. I'll go get a TV, Sheriff Feasty saying, look, I got one. There's a Best Buy down the road. I'll be back in 10 minutes.
Believe it or not, I've actually done something similar with AV cords.
Real quick, Russian name says, well, I've taught lectures on computer graphics at university for 4 years, and after thinking about these pictures, I'm even more mad. You can have illusory colors via dithering, and even one pixel can change how human brain perceives shapes. That's CSI Looney Bin.
Are you talking
All
about
right,
82?
bring it up if you would.
What is that?
82 is the slow.
No, I think the best picture is on the original drone or the normal speed one.
73, you say so.
If you say so. Judge,
Oh, is-
turn your ringer off.
Judge,
Turn
I think
your ringer.
using the defense, we've
Or-
got the exhibits on our one of our laptops that I think Mr. Stu has. I've texted him to come on over, but I think Ms. Wisco is graciously going to be able to play them for you. I would recommend watching them on the 4K TV. I think that's the best.
4K because you need the
way to see
visualization.
them. So we can set that up. There is the full drone footage. There is the
4K is
slowed
not
down
automatically
drone
the
footage.
best.
And then, of course, we have the photographs that Mr. Armstrong had yesterday. So,
Native resolution would be the best.
Humpty Dumpty really lost control there.
I mean, unless it's their goal to piss off the judge, thinking that when he gets pissed off, he calms himself down and may then allow something he wouldn't normally do it. Maybe that's their plan. It's risky. I wouldn't do
tell you-
it.
Yeah, but here's the thing, he's appeared, according to
I think they
Westlaw,
just-
Binger's appeared in front of this judge 400 times. He knows how to push buttons and how far he can push and how far he can't. He knew he
So
would never
they're
get
gonna-
sanctions.
They're going to tell the
again,
judge
I would
that right
recommend,
here
like
he
yesterday,
sees the gun
you
being
watch
raised.
4K TV,
This will be hilarious.
which is if it's not 4K quality.
What's that?
Is it this TV
It's your TV.
adds pixels to something unless it's 4K quality? It does
Where's
next
the
to
evidence on
me.
that?
It's your
It's
TV.
common sense and judgment, Jim.
There's
Oh shit!
Oh,
Are
Jim,
you saying I'm lying?
I have no idea.
I'm saying there's no evidence.
calling me a
I'm
liar?
asking.
But
I'm
it
saying
gave
there's no
another.
evidence.
Well, it's common
Questionable argument.
sense.
You brought in this TV show and said
Yeah,
brought in the
4K
TV.
drone.
you brought in the TV.
They're getting heated because this is critical.
And they know
Things
their
may turn
expert
on
just
this.
blew this up yesterday.
Yeah.
I mean, if Richards is 100% right, if you take 844p footage that they have here and enlarge it to 4K, you're doing the exact same thing as pinch to zoom, yet they know even less about the algorithm that's being used because it's whatever proprietary algorithm is being used in the upscaling software that's picked by whatever TV manufacturer they are. And if it's a cord, it's probably like a shit brand from Walmart.
This is the unedited.
Okay.
Is this unedited?
Yeah, this is the unedited.
73.
All right, judge is right there.
The judge, we're going to be focusing your attention right here at the base of this
Right.
sign. Okay, that's where the defendant is going to come into. Go ahead.
I don't think he's going to see anything.
He's not going to see anything. Look,
I
judge,
hope-
don't you
Can't
see?
anything.
Don't you see the gun?
It's crystal clear.
Okay, you can stop.
Where's it supposed to be?
How did he perceive a gun being waved?
Same quality as our version. So-
How did Rosenbaum perceive a gun?
Our
being
version
waved
is
in
much.
that
Our
second?
version is much clearer.
Oh, your version is
Well,
much
yeah.
clearer. This
Yeah.
is the evidence that's admitted.
Mr. Stutz.
So what you're showing me now is, this doesn't show anything. This
Doesn't
is
show
what-
anything.
the defense-
Yes.
But this is only one of 4 or 5. They have much. They have 3 more.
No, they said this is their best one. They
No,
said
I know,
this is the best one.
But there's other ones also. They have like
The-
cave drawings.
The judge
Kyle.
just said, and that's the key. So this is it because that didn't show anything. And of course, it doesn't show anything. It never
Look at
did.
Kyle's expression. Boy, he
Yeah.
knows the stakes are. We're all in
Yeah.
on. He's all in on this one.
The reason provocation is so big is because
Kyle, stop
if it-
looking at the law and crime camera.
Just playing weird.
When you
Oh,
sit
it's
next,
playing weird now. Are you fucking kidding me? It's playing weird.
your
Judge,
case
you saw
is
it yesterday.
garbage.
Totally.
No.
It's a different file.
Straightening the time.
The reason, so just to explain to the audience, the reason provocation is such a big thing, this provocation charge is such a big thing, is because as Rungo the Bailey was saying, this is how they could thread the needle. Once they can, if they can establish and allow the jury to make a finding that Kyle provoked them, and that mitigates against his right to have self-defense, or changes the yardstick as to what he has to do for his self-defense, all of a sudden everything now changes as what we watched for the last week and a half. And all of a sudden now, this flimsy, ridiculous evidence is trying to be used by the DA as a basis to say, oh, he provoked them, and that's the reason why lunatic Rosenbaum went up and charged him. He was trying to protect Zeminski or whatever. And there's ridiculous, clumsy, pixel-added, impossible to see anything. Is there best evidence that he provoked them, and because of that provocation is now should be held to a different yardstick and basically be stripped of his right for self-defense.
Look,
And-
it's bugged 4K mechanics, dude. It's bugged 4K mechanics. It's
What it-
not playing right.
What it really does in terms of the provocation instruction is if you've got somebody who's kind of wanting to convict, but they can't see it, it gets them a way to get past the whole obvious self-defense thing and to say, oh, well, it doesn't matter if it's obviously self-defense because, the gun. So it's not going to help, help the prosecution with a juror who's looking at this sort of fully. But for somebody who's looking at it with an eye to conviction, I think.
No, you're 100% right. That this is a critical moment on the self-defense claims, because if they get that provocation in there, it's just like Joe was saying, they have the opportunity in the mind of a juror to mitigate and say, he provoked this, he deserved it, and just having that instruction, they get to read into he shouldn't have been there. He shouldn't have brought a gun. He shouldn't have walked into the hostile crowd, none of which is actually legally relevant. But in the mind of the juror, it is. And that's
And
why
by-
this instruction is so
Exactly.
dangerous.
And it goes further. If there's a break here, it
Uh,
goes
Billy-
much further also because the jury, once they hear that provocation is a basis that we can change our yardstick for measuring Kyle, they won't just look at this moment. In their mind's eye, they're going to say he provoked them by showing up there with the gun. And
That's
that
exactly
now
what I
the
was
judge has
saying
told
earlier
us that
today.
he provoked them, that they can find him guilty because he provoked them. That's if they see that provocation charge, they're not going to be looking at this stupid video. They're not going to care about that. They're going to be thinking about the fact that by he walking around there with the gun, he provoked them, and everything that happened is his own fault.
Yep.
That's the danger of this
That's
provocation
exactly
charge.
what it is.
MSMPCA or CPA, thank you for the sticker of the pair riding a rocket. That was weird. MNSISU says the first to third most important evidence is drone video where Kyle is 10 pixels tall. The fourth is the idiot detective saying he sees that 10 pixels pointed gun. And the fifth is a zoomed in picture of a blurry smudge. What an excellent argument. Do you even know on the picture where Kyle Rittenhouse is right now, Kraus?
This is the
He
zoom in or the
watched
regular?
on his 4K TV.
No, this is the regular. They brought
So
their
looking
regular.
right here, this is the defendant. He puts it down, he raises it up right there. He has it pointed until Rosenbaum approaches, then he runs it around.
Try it again, please.
You try it again.
please.
And can you slow it down?
Nope.
We have a slow. That's what you watched yesterday.
This is why you never want to allow slowed down video, is because
here's
it
the
can
gun.
create all these, it should be seen
there's
as it
the
would have
gun
been
right here.
seen.
As
See the
no
guy
one
in the
there
white
saw
shirt?
it. There's no human there saw it.
Yeah.
I can't see
Looks
where
very
he
similar
is.
to that when he points it here, Mr. Rosenbaum.
Well, we know he points it there after he's already being chased by a lunatic.
Here, Stu, let me pause it 1 second and please.
Let me
Let me
please
just keep
convince you.
suggesting this. Yeah.
Pause. Right here. If you watch it, when he goes right up here, he puts the fire extinguisher down gently. It topples over, and then he immediately raises
So
up
gently that it topples over.
like this. And the gun is right, we argue, right here. And he stays in this position like this until you see Mr. Rosenbaum come around. So Mr. Rosenbaum, if he is yelling gun, 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 we would argue it's to warn all these people that he is pointing a gun at them, and that he is chasing him out of the area
Sheriff
to
Dees is
avoid
laughing.
danger. But if you see right here, the state believes, with all the motions taken, that's the gun. And here's the
You need a continent-sized TV to see this.
You're screaming gun, gun, gun. Wouldn't that be not to provoke them, but to
we
tell
can
them to go
talk
away?
about this on closings. You want?
I was just curious.
What's that?
All right, all right, all right.
So why don't you play it from the beginning one more time? You see him drop it right there as Mr. Rosenbaum approaches. Or lower it, I should say. Would you like the zoomed in or slowed down one?
I'd like to see the enhanced one now.
In normal speed or slow speed? Do the zoom in normal speed.
Zoom in normal speed.
Do you need a number?
Billy Witch Doctor says, didn't Greer need to get his own HDMI cable when he sued Taylor Swift? Yes, he did. And he went and got a 3-inch HDMI cable from Radio Shack, and it didn't work. The Dragon's Treasure says, I broke my goal of 1,000 in one day, and it's not even noon. Thank you, everyone. Coupon code 4 doors more whores at the Dragon's Treasure for all your anime-themed tea
So this
needs.
is
Gotta
slightly
go.
cropped
Keep it up.
and normal speed.
This is when you say, Judge. No.
Oh,
All right, now we're at the enhanced video. What they should do is say, Judge, do you realize that blurry blob that we're seeing the picture of is from
like
this
your
video?
phone.
That's the same thing that we're supposed to be looking at. And so if it doesn't make sense when it's stopped on the one moment where they say it's happening,
so
how are we going to say it's
this is
happening?
the
in
defendant right here. You can see the AR-15 is on his chest. The fire extinguisher you can't see right now. It's blocked by this man in the
directly at
wheelchair.
Kyle for that.
But you'll see him
millisecond
walk
that he
up
waited to
again.
go.
He will
So insane.
gently place the fire extinguisher on the ground, although it will fall over, and then he will immediately raise his gun up and point it at the individuals who are over here, who I think are right now blocked by this street light. But they're the Zelinskis. Okay, go, Brian. See him lifted right there. He's holding it right there until Mr. Rosenbaum approaches. You see the very distinct motion of him raising his arms, and you see the black gun being raised. One more time, please.
You'd agree if that's true. He's doing it open to the camera.
Well,
So
you know what?
No, I would not say that.
it's okay.
Somebody's pointing out that this TV apparently
So
does
here's
use
the
AI upscaling.
Puts it down and raises
Of course
it
it
right
does.
there. He still has it up right there, and then he drops it and runs.
I don't know if you can even buy a TV without AI upscaling right now.
Would you like the slow
Yeah.
down version?
I mean, you
Might be
could, but
shitty upscaling. Might be good upscaling.
Slow down version, please.
I would just remind the judge that's what I would say. Judge, that blurry blob picture you saw is from this video. That's what they're asking you to see in real time. They want to convince you that that's what you're seeing, even though you clearly don't see anything happening.
None of us see
So
anything.
here's the defendant here.
And the
There's
DA knows it.
AR-15
I want to hear him
right
say
there.
it. And the DA knows it.
Play it,
I'm lying
please.
to purpose. The DA knows
So he's
better.
coming into frame. He drops the fire extinguisher and he raises it right up. He has it up right there. You see him bring it down, and you see him start to run. He's pointing it at Joshua Zeminski, who probably is vandalizing or committing arson, but that's another.
Where's Zeminski's gun?
We don't believe he has his gun out at that point.
Wait a minute.
Wait a minute.
He fires it. What, I'm sorry.
I said, where's Zeminski's gun? I meant, what I meant to say was, does it depict Mr. Zeminski,
Shooting?
Mr. Zeminski's gun?
At this point, no, it does show him shoot in the air.
Well, that's over later, over there.
Yeah.
I'm talking about at this point.
I don't believe it shows Mr. Zeminski's gun.
Does it show Mr. Zeminski
Can you play it again, Brian? He's kind of
or
hidden.
Mr. Zeminski?
You
They're
can't
kind of
even
hidden by this light post.
you can't even point him out. That's how bad the video is.
this is something people never understand with video, is just how often video evidence is crap.
What I inquired is, well, boy,
What I don't understand is we have 19 different angles. This is the only angle that you could possibly
what
see
I'm
him waving his gun.
inquiring is whether
That's what they claim. Well, that and the FBI drone footage from a mile and a half in the air.
Why couldn't they see? Why wouldn't people see it from the other direction?
Because it's made up.
Whether or not it's
That's what I'm saying. That's what he should be saying.
that he is reported to have fired
Where-
seconds
does it-
later.
where does
The only
Zeminski
time
go?
anyone sees this is when it's artificially enhanced with pixels being made up. That's the only time anyone sees it.
And they don't even
We
see it
only know
then.
they're there because the FBI video.
Yeah.
You can kind of see they're blurry. We did not try to do any.
So you can't tell where he's pointing a gun if he even
We know
raises
from
it.
the FBI video. We know from the FBI video, Your Honor, that they're in this proximity alongside the Duramax. But
Then
because
show us the
they're
FBI video.
Closed, and the Duramax is a
I don't
dark
think the judge is
vehicle,
gonna buy this.
And of course, other issues with the video. It's not, and there's poles.
But he won't strike the
so-
evidence, though.
Issues with the video.
Which we can show you does give you.
I've seen it.
It might be helpful after seeing this now to see that because it kind of gives you a better visual. So.
If you play it, I think I can play it, please, Brian.
I can pretend to know where they are after saying we don't know where they are.
I believe
I
they're
think
blocked by the light post.
they're
But they are
blocked.
right here.
I think this is
I
one of
swear
them
they're
here.
there.
Moving. It's very hard to tell in this video.
Amazingly,
then
Zeminski's do
they
not
walk down
react
this
to
way.
having
This
the
is where
gun
he-
pulled on them, by the way.
We don't accept the defendant's story that he had his gun out because in the video you clearly see Mr. Zeminski pull it out of his pocket, fire in the air, and then put it right back in his pocket. So unless he had the gun out and then put it in his pocket in these few feet, we're not accepting the defendant's story. In fact, we believe this contradicts his story that Mr. Zeminski had his gun already out because you see on the next enhanced video, you see him pull it out of his pocket and fire it in the air quick and then put it down.
He keeps it down on his side. He's walking right down the sidewalk yelling, "That dude just shot somebody." You can see the gun clearly in his hand.
Well,
Not
I
in this
think
video.
that sounds like a great argument. But did you want to make any?
Object to all of this.
Before I make a decision?
Well, you're gonna see. I'm cheating here, right here. You're gonna see what you believe that you see. Okay. So that question is, does that video provide enough information to give an instruction on provocation?
And Your Honor, how does, if we take everything they've said, that's true, how does pointing a gun at Zeminski?
No.
Don't steal
Rosenbaum,
victory from the jaws. I mean, defeat from the jaws of
they
victory.
say they don't know each other.
There's no evidence of that. He called Mr. Rosenbaum's dead.
He's screaming gun, gun, gun also because Zeminski just fired. He's screaming there's a gun somewhere.
Any real basis.
Well, the evidence, okay? The evidence in the records of two people is that Mr. Rosenbaum had twice before threatened to kill the accused. So is it, what is the legal effect of a person who, if he made such a threat, what legal justification?
He
does
would have to retreat
to
and
chase
clearly
after
communicate.
the accused?
Oh shit. He would have to communicate to Kyle, I'm not going to kill you.
In such
if
a way
it-
as to not put the defendant into a position of being
Wow.
a provocateur.
Great.
We are
point.
absolutely
That's not
not,
well phrased.
we are not accepting the evidence that that threat was made because there are different accounts of where and when it was made. And it's like
Because
the
there's
only
different
5
threats.
seconds not caught on video all night. So, but like you said, Judge, it'll be a great argument. And I do not believe that Mr. Rosenbaum does not give up the ability to be provoked because he may have said things an hour earlier. If this individual, now remember, there is evidence in the record that he was accused of pointing guns
Threats
at
wear off
other
after an
individuals
hour.
for property
It's amazing.
crimes. The defendant admitted he responded sarcastically to one of them. On the video, he sort of sheepishly and quickly walks away after admitting he pointed a gun at someone for property crimes. The state's belief is that he pointed a gun at Mr. Zeminski for another property crime, and this dangerous behavior, pointing this loaded, powerful weapon at someone for, at the most, perhaps stoking a fire that's already been lit, would be provocation.
All the fires
Committing
lit
this
by
unlawful
Zeminski
act would be
and
provocation for
Making
anyone
up facts.
to intervene and try to chase him away, whether or not it's threats have been made. And I know Your Honor takes these threats seriously, but we've also seen thousands of threats to kill that have never been acted upon. This guy,
But this
Mr.
is
Rosenbaum,
by
was
someone
described as
who's
a babbling
charging like
idiot.
a bull.
There's no evidence he ever caused any physical harm to anyone
Was
that
he in a
night.
different trial than everyone else?
And frankly, even if he had threatened, he had no means to carry out his threat. So
What?
Uh,
Look at Kyle's face.
as you said, it's a
Are you
great
out of your
argument.
mind?
There's evidence in the record, not just by video, also by testimony. And there's enough evidence to give this instruction. If the jury does not accept this argument, if we do not meet our burden, that probably is beneficial to the defense, but it should at least be argued as the evidence does support it. And it goes directly in contrast to what the defendant testified to.
I think he's not going to give it.
Do you want to respond?
Judge, it's been hashed over.
Well, it's the jury's,
No.
it's the jury's case, and I think they should make the critical decisions.
Oh my God.
No.
Why would you let this argument go? You were winning it.
Why would you?
Why they let the defense is so awful here.
My decision will be to submit the case to the jury with the provocation instruction.
Fuck Oh my
God.
No.
And argue the strength or lack of strength of the respective evidence. So I will give that instruction, and I'll give the. You didn't dispute the retreat, did you?
I don't think it's, I did. I don't think it's, if you look at the comments, it's not necessary. It says right in the comments, the committee concluded that while reference to duty to retreat is arguably unnecessary, given the potential relevance of retreat to the reasonable use of force, it's advisable to continue to publish it. It is intended to be optional in the sense that it is to be used only when the trial judge concludes that retreat is an important issue in the case, and the jury's understanding will be aided by a statement of rather than the general legal standard that applies. So I don't think that under these circumstances, there's any, can't say it's unfavored, but if you look at the comments, there's no reason, in my opinion, to give it. He does retreat. There's no argument about that. But I don't think it's necessary to be given.
I can't believe they did not continue that argument.
Yeah. It is appropriate useless. In large part because this was that there is no duty to retreat was mentioned in opening. I believe Attorney Trofsky referenced it in a cross-examination that the defendant had no duty to retreat. So I believe that there should be, that's been put out to the jury. There should be a fuller explanation of what that means, that they can decide and they can see if there was opportunity to retreat. We see the defendant has plenty of open space in which to retreat. He does so right after shooting Mr. Rosenbaum. And also,
this is insanity. This is insanity.
Everybody was scattering that, and that dramatically changes the situation.
If you look at the FBI video where he ran to, there was absolutely no one there before the shooting.
Oh my God. How much further can back
the FBI video does not pick everybody up. The Zanin video shows it clear as day. There's 100 people over there bashing on windows.
Yeah, the Zanin. I don't remember which it was. I think it was Zanin. Video to me depicted a large number of people who were engaging in violent activity. Well, property violence, but it's still they're using clubs and wrenches or whatever else to be doing destruction to those cars that are right in the area which would have been the path of flight for the accused. And I'm wrong about that?
It's fake evidence, fake narrative. Everything here is
video. You hear the 5 gunshots.
Yes.
You hear the first gunshot, which is Mr. Zeminski, and there's kind of a flinch of the crowd. And then you hear the 4 shots that Kyle fired.
Yeah, let's have a look at it. I sure formed the impression when I looked at it that this is just to the south of the area where the shooting took place, and that there was a very large group of people in there who were intent on riotous activity.
I agree that in the southern portion of the lot there is. The defendant testified that his first instinct was to try and head north on Sheridan, that he could not because Mr. Rosenbaum was there. But as their testimony is that he was somehow trapped or blocked in these rather loosely parked cars. And you will see, I believe in the video, that the route the defendant takes after shooting Mr. Rosenbaum.
I don't want to hear about after, because after, that's a different situation entirely.
All right, well,
watch the video. Let's watch the video.
Oh,
God, defense, you're winning. He hates Krause. He hates him.
And they're just sitting there mutely.
Sure, you can put the sound on.
This is the time to dunk on them.
Exactly.
Get in there.
You hit the
rest
guy
being
and he's
defeat, the
staggered.
jaws of victory.
Follow him.
Yeah, don't just give him a chance to rest up, and especially because Crows can't make arguments when he's mad.
Over here, past the hospital.
No one stood in his way. Grossly ineffective defense counsel.
Most frustrating thing is they were winning that argument.
Yeah, the judge
And then they
has
just-
completely on their side.
Can you pause it, please? Or go
Why?
back 2 seconds. The defendant runs here. There's no one in that area.
I will mind.
Wait for the gunshots. Which comes in a minute and 10 seconds approximately.
Look at all those people there.
Just let it play. Starting the car.
This kid's being railroaded. And his defense is as culpable as anybody else.
I think this foreshadows what the next motions are going to be like.
Yeah.
There needs to be a motion to well, if he loses, they need to appeal based on the improper admission of that fucking blurry photo and the video enhancements from an expert that's not an expert.
When no one even testified that it fairly and accurately depicted anything.
Highly prejudicial.
They did preserve the objection of that photo from the expert.
Oh, that's
They
great.
didn't from the drone video.
Oh, shit. They shooting. Oh, my God.
It seems to me that there's quite a bit of fight from that otherwise congested area after the shots are fired. So prior to the shots being fired, there were quite a crowd there. What,
Judge, I don't believe there's a crowd where the defendant ended up retreating to, but
Seriously.
ended up is after the shooting had occurred.
I understand. So my main reason for wanting this instruction, or our main reason, is that the defense
evil.
has already stated that there is no duty to retreat. So they've already put that in evidence. I imagine they will argue it again in closings. So I believe the jury should properly be able to instruct on the law regarding retreat.
Did you want to respond?
Your Honor, he's arguing the instructions. I'll keep my mouth shut. I said he's arguing the instructions. I'll keep my mouth
You
shut.
saw the video, Judge. There's hundreds of people with weapons causing damage. What happens after doesn't matter because it happens after. And I'm trying to do this on the law, which is that it's unnecessary based on the fact that self-defense is going to be given. And the question was the use of force in the situation reasonable? That is contemplated by not giving 8-10. That's what the committee says.
My inclination is to give it, but if I find it's adequately covered in the other instructions, then I won't.
Okay.
All right, anything else?
Judge, I don't know if there's any jury instructions. Obviously, this case, anyone can pull up any video testimony of anyone testifying. I'm just wondering if the court feels it appropriate or allowable to play portions of testimony to the jury on closings.
You mean from media sources?
Yes.
Wants to play court
What?
TV.
Well, I'm not saying
Well-
we want to. I'm saying we should talk about it now before anyone tries.
Well,
to
that's a
cover it.
good point. I don't want to specify one.
They should play us.
Court TV is
Yeah.
They should play us covering
and
it.
I might add, has done a magnificent job in this trial, in staying out of my way and just keeping things going. I think so. I'm not saying you shouldn't follow that. You could use any source that is carrying it, except not one where they're commenting on it one way or another.
Uh-oh.
Judge knows
Racism.
about us. He knows about us.
He knows about us.
The judge is like he's like, oh yeah.
So unless there's some objection, I don't have any problem with
Anti-Semites.
that.
We're not seeking to do it. I just wanted it out there before someone tried to do it.
I'm happy to agree that we're not going to do it.
Oh,
I
okay.
just-
Well, let's
I
do
just
that
want to
then.
be blindsided.
Let's
so.
do that. Okay, so there won't be anybody doing that. Now, but you bring up a good point. If the jury goes into deliberation and wants to look at some of this evidence, of course, one would read the law, I think, nowadays to say that any scrutiny by the jury should be in the presence of the court here in the courtroom. I very, very strongly disagree with that. I think that's antiquated. I think that that's based actually on a case I tried right here. Once again,
Of course it is.
I was there. State against Maurice Pucci Franklin. And
Wrote it with
I'm not going
Madison.
to go into my usual dissertation on that, but that led to, I think, the Anderson case about showing videos and things. The law actually developed around recorded statements of the accused as opposed to videos of the actual events. But I think the general rule now is supposed to be that we're supposed to do all this under judicial scrutiny, and they have to ask permission, and then we have to supervise. One of the things that I find most offensive is that we've got to scrutinize it to make sure they don't play it too many times, so they don't overemphasize some aspect of the evidence. I think that's what the laws,
Oh,
what the
gee.
cases say. And I think
That hasn't
how
happened at all in this
dare
trial.
us, the founders of the Constitution, have juries because they don't trust the judges, and the judges have spent the last 225 years returning the compliment by telling, always suspecting that the juries are going to be up to no good. If this were a bench trial and like this, I watched it. How many times have I watched that video now?
You should have had a bench trial.
And you know what? I could sit and I could watch it maybe 50 more times. And in fact, the famous Boston Marathon bomber was resolved because an agent from the FBI watched the video over and over and over and over again and finally realized what nobody else had caught, which was that Mr. Tsarnaev, who's now under death sentence, temporarily not. We don't know what the outcome will be in the Supreme Court, but that everybody else was looking one way and he was looking the other. And it took numerous times looking at the video to solve that crime. So for me to monitor how many times the jury looks at something, if we're a bench trial and I looked at it 100 times, and I finally decided I better not look at it anymore because I might prejudice myself, I'd get reversed because that's an absurd thing to say. So I don't want to sit here and monitor how many times they look at something. I did that once when it was an attempted murder case of a police officer, and the jurors came down and they're told they can't even discuss it with one another, but they can't resist, and so they're saying, oh, look at that, and then I send them upstairs and they're not looking at it again. And I think that's really frightening. So I think if they want to see the exhibits, we should give them the equipment to see it and let them do what they want with it. So that's what I think. Now let me hear from you.
1,000 times.
I agree with you that is antiquated. I think this is the ideal case where giving them access or setting them up somehow with the exhibits would be great.
It's going to be a 2-week-long jury.
I saw this as a issue. I did ask people at the Department of Justice to look into it. Not a formal opinion. They indicated they believe it would be reversible error. I asked even if there was a stipulation and if the defendant agreed, and they thought it would still be reversible error under the current law, and also, and I'm not saying it would be ineffective, but they thought it would raise an ineffective assistance of counsel claim if there is a conviction. I do not want this case to be a test case on long-established law. I agree that the law is antiquated, and with the explosion of technology in the last couple decades, it needs to be changed, and perhaps we can do so legislatively. But as it stands now, the state feels that we should follow the procedures, as antiquated they may be.
Defense?
I don't want them having a free-for-all up in the deliberation room.
Okay. Well, I'm not going to cram it down on this case. One day, with a short trial, yeah. This is crazy. It's just absurd. And
Your
I'm the
decisions
one,
today
I
have been
guess,
kind
was
of
the
crazy and
dinosaur
absurd.
on technology, but I certainly respect it more than our law does. We need to talk about the lesser included offense instructions, Mr. Rittenhouse. The effect of these.
This is the
Right now-
colloquy he
right
referenced
now,
earlier.
The charges against you, which are stated in the amended information, counts 1 through 6. The district attorney has to prove each of them beyond a reasonable doubt in order to obtain a conviction on that particular count. And there's something called lesser included offenses, and I'm sure your lawyers have discussed it with you. But I want to make sure that you understand it, and I'm required to do that. And if the district attorney is not able to establish your guilt on the charged offense beyond a reasonable doubt, then the jury is instructed that they must acquit you, find you not guilty. If a lesser included offense is presented to the jury, any of the ones we talked about, which are less serious crimes, carrying a lesser potential sentences, if I allow those, then the jury, if they are unable to agree that you're guilty of the charged offense, will have the opportunity to consider whether you're guilty of the less serious offense and could return that as a verdict, as an alternative to instead returning a verdict of not guilty. So you are, by having a lesser included offense included, you're raising the risk of conviction, although you're avoiding the possibility that the jury will end up compromising on the more serious crime, and you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. Any question about any of this so far?
No, Your Honor.
Okay. If the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you. They must find you not guilty. And they cannot convict you of more than one crime on each count.
And that's how it practically works
Okay.
out every time.
Your lawyers have objected to some of the lesser included offenses and not others. They have, on some of them, they have agreed that they're appropriate. You don't have to join in that agreement if you don't want to, and you have the legal right to overrule them. And we'd have to talk more about it if you decided to do that, but you would have that legal right and say, no, I want to go to trial on just the charge offenses, all or nothing, and make the decision to force the district attorney to prove each case beyond a reasonable doubt. That would be your decision. Have you had enough time to talk with your lawyers about this?
I have.
Have you had enough time to think about what you're doing?
Yes, I have.
You think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
Has anybody promised you anything in exchange for this?
No, they haven't.
Is your mind clear today?
Yes.
Are you feeling all right?
Yes.
Have you ever been treated for a mental or emotional disorder? Well, let me ask you this. The more important question is there any reason for me to be concerned that you have some kind of disability, mental or emotional, that would prevent you from being fully aware of what your options are and making a rational decision? Any reason I should be concerned about that?
No, Your Honor.
Okay. Any other question anybody wants to ask on this?
Was I believe, because he's in therapy. I don't think he has a mental illness or anything.
Okay.
As a result of this incident,
Okay.
he has PTSD.
Okay. And but that doesn't affect his judgment or reasoning power at all?
So,
No.
He's wagging his head no. Okay. Anything else before I accept his decision on this?
No.
All right. So I'll accept the waiver and instruct accordingly along the lines that I've already indicated. Anything else today?
Judge, while you were doing the colloquy, I looked at my email. I got another screenshot of someone saying they know someone of the jury.
Guys,
I forwarded it along just for transparency reasons.
Guys, him objecting does not mean that
to the
he
defense
would
end of the court.
win that objection. He'd be objecting again, over the non-objections of his counsel.
Disappointed.
That does not mean he would actually win
I
those
didn't get it
objections.
yet.
The judge would likely just overrule them.
Oh, wait a minute.
Why? Where's the motion for direct verdict? Where did
Oh,
that
yeah,
happen?
here it is.
We haven't gotten to there yet.
Is
All
that
right.
coming?
I don't know if it's coming today or not.
When would it come if not now?
Yeah, I kind of heard the opposite, and maybe I misheard it, but the way I heard it was that Kyle can actually force it if he wants to prevent lesser includeds. But maybe I misheard it.
Why wouldn't you do that?
I don't know. That's a good question.
I
Because
don't
he's getting bad
understand either.
advice.
I mean, maybe I misheard it because I kind of zoned out in the middle
All
of
right.
it.
Thank you.
All right. So what's going on now?
Are we done? Is court adjourned? Are we not going to have any more discussion? Oh, we got a new player entering the stream. Just a minute. Let me make sure he doesn't. Yeah, this looks like court is adjourned for the day.
Well, so we're not doing the motions. That's great. That's good.
Where's
news.
the
Hey,
directed
Hoglaw's
verdict?
here. A new participant.
Welcome to Hoglaw.
Yeah, that's about right
Hey.
for my timing, right? No, thanks for inviting me.
It's over,
Yeah.
Hug. We're retiring. Yeah.
Well,
I should
thanks
have
for coming,
invited you
everyone. Have a
earlier,
good day.
but
Well, no,
I
it's just me tweeting out every 3 seconds when something happens as I try to get over this cold.
I
but,
saw you tweeting and I was like, oh, he's watching. I'll invite him on. Well, welcome to it. What are your observations of the day?
Well, I mean, I think the main takeaway was the one that you guys made, I think, very well, which is I don't think the defense ever really got around to the big deal with the visualization there, which is, Your Honor, you sat in front of this TV we rolled in for however long it was, 20 minutes, with a pointer, and this is a capital case. Do you think the jury can actually hit a burden of beyond a reasonable doubt with what the state is saying on these kinds of things? And I don't think the defense ever really got there. And I was as surprised as you were to have them say, yeah, we've hashed it out long enough. Do what you will, Judge.
Yeah, that was baffling. And in my opinion, they had the winning side of the argument. And you sit there, and then when you consider that even worse, a couple minutes later, they argue that it would be improper for the jury to have, they state that the jury it's against the law for the jury to have unfettered access to replay the video over and over and over. And it's like, Judge, like we were just doing at the TV a second ago, and you're including an instruction based on you seeing the same video 15 times in a row with someone directing it with a pointer. And they're saying that that'd be improper for a jury to do so. Why are we including an instruction based on that? It doesn't make sense.
Yeah, and I don't know whether the judge has been chastened by some of the coverage he's gotten on some of these points, or whether this is just his modus operandi. Anything remotely controversial sent to the jury. I know a lot of judges work that way. But yeah, I certainly understand the consternation. And as I was tweeting out, certainly if you get that provocation finding, which already is a word that I think we as lawyers read differently than fact-finding jury members do. Like, what is provocation, right? There's arguments on Twitter half a mile long about the fact that him showing up in Kenosha is provocation. That's obviously not the standard here, but in a jury room, I mean, you just don't know.
So I was under the assumption they'd be arguing their motion for directive verdict today or their motion for mistrial, but I guess that has not been submitted yet. Do you know anything about that happening or not? It's hard because you can't follow the filings in Wisconsin very easily. Anybody know anything about that one?
I just hope they're doing it.
They said they were going to file the mistrial. So you'd hope they'd file the motion for dismissal, because even though, I mean, I think they lost on some of the evidence things today, that's a different question than whether or not the state has adequately raised to the legal standard required in their case in chief that they've raised the issues. So I'm with Joe, and what he's been screaming is like they've got to file the motion, like they have to do it.
They've been so passive throughout every stage of this, in objections, in following that and raising that motion at the close of the state's case. Today, I would have walked in there saying, "Why are we talking about jury charges? We should be talking about which charges are going to remain, because if any." That's how I would have started. They're so lacking in any sort of aggressiveness on his behalf. Even like I said, it was painful to watch how Binger got to badger him, and with zero objection. It's almost as if this kid has been stripped of his right to counsel. I'm speechless. I'm apoplectic. That's the word. I'm apoplectic.
I feel that.
Yeah, they started off getting some early wins on jury instructions, which were great to get, or not on lesser includeds. Things were going well, but they lost at the critical aspects of today. I mean, the critical elements that they had to hit. That provocation instruction should not be in there. There is no evidence in the record, and the evidence that is in the record is improperly in there because the defense failed on those issues, except maybe the blurry picture. But their failure to connect that blurry picture that the judge just told them, I don't see anything but a blur, and say, that's from the video, judge. They're asking you to look at this and just with motion pretend that you see something. How they don't say that is mind-blowing to me.
And because of that now, and because of this, okay, so you have ridiculous lack of foundation still shots, right? I mean, there's lack of foundation because they never said that it fairly and accurately depicts. So you have evidence that comes in that should not be there. It's basically nonsensical evidence, which a lot of it, with the whole thing with the left-handed, it looks conflicting, and we have no way of knowing if Rosenbaum even saw him moving the gun, if he was even looking that direction or looking for that millisecond to his left and didn't even see him do it. Then
they couldn't even think. Sorry, go ahead.
And we don't even know that Zeminski's not in the frame, but somehow the state, despite any testimony, there was zero testimony that Kyle waved a gun at anyone. Zero witnesses coming forward saying Kyle waved a gun at anyone. All of a sudden now the state is going to get up there for 2.5 hours and start saying how Kyle should be stripped of his right for self-defense because, hey, we know he lost on self-defense. Anyone with half a brain realizes he had self-defense, but he should be stripped of that right of self-defense because he provoked this whole thing. Now, all along, what does the state know? They know that for the last 14 months, every narrative that this jury has been hearing is Kyle provoked them by showing up with a gun. Now, based on this ridiculously altered, lacking foundation evidence of a picture and a ridiculously baseless narrative that zero people have testified to other than Humpty Dumpty there himself. But no one's gone up on the stand. So we have ridiculously altered evidence. No one's sworn to that it's actually reliable at all. And you have Humpty Dumpty making claims as to what the hell is going through Rosenbaum's head, even though there's zero reason, no one's testified to it. No one saw Kyle waving that gun around. So now what's going to happen is they're going to have a provocation charge. And what happens to the mind of the jury that has been saturated on the notion that Kyle provoked them by showing up with a gun that night? They are going to hear that provocation charge, which is really only limited to that waving of a gun in a millisecond there that nobody thinks really happened. That maybe he waved a gun. So they're going to hear this whole provocation charge that the state is only able to get in on fake evidence with a fake narrative. And now they had this whole provocation charge. So in the minds of the judge, they're like, yeah, well, we kept hearing for 14 months how he provoked them. And the judge just said, if he provokes them, well, in that case, he loses the right to self-defense or whatever self-defense he did. So now the state just salvaged their case, which they lost for the last week and a half, because basically, in the minds of the jury, they're going to take the provocation they heard about him showing up with a gun and attach that and say, well, I guess if he's provoking that, if that's one form of provocation that strips him of his right to self-defense, so too the provocation of showing up with a gun and strutting around there like CNN and ABC News and MSNBC has been telling me for the last 14 months that takes away his right to self-defense. I guess the judge is telling me that they're all right. It takes away his right to self-defense. And this really is a ridiculous basis that this kid's life could be destroyed because of a fake evidence and fake narrative and the fake lies from mainstream media. And it's sickening display that America had to watch this corruption of our American judicial system.
Joe, tell me how you really feel.
Yeah, I was about to say the same thing. But I mean, it's criminal that the Richards and Sheriffisi do not recognize that this is the linchpin of the state's case. They've been arguing this provocation by association argument the entire time, and they're fighting on the provocation thing, and they're giving up at this crucial time. And when the moment they say, where's Zeminski, or judge like, where's Zeminski in here? He's like, well, we think he's behind these lights. Judge, they can't even point on their best evidence where Zeminski is, and we're supposed to believe that Kyle pointed a gun at him. What the hell are we doing, Judge? Sorry, Nate, I didn't mean to cut you off.
No. I'm going to say it. This is all the defense's fault for putting Kyle on the stand.
Yes.
Because the first time we heard about this was when they put Kyle on the stand. They offered it up, and that's the first time we heard about him pointing a gun at somebody. If Kyle doesn't take the stand, we never get any evidence. And this is the reason why we all said in unison, why are you putting the kid on the stand? Because it can only hurt. It cannot help. And now it has helped in spades. It has recovered a dead case. This is why you don't put him on the stand.
This is lawyering, though. It's the lawyers screwing it up. It's not Kyle. Kyle was masterful. It's the lawyers not being good advocates.
Yeah,
it was a bad decision. I'm not all following that. It's just that it's the reason we're where we are is because they completely suck at every stage.
Yeah,
well,
and what
the judge
what I
shouldn't
think
have gone along with that. That's just. I think he's just afraid of what people are going to be saying about him if he takes some strong stands and says, "Hey, listen, you guys have to follow the law. This
right.
evidence is garbage, and it doesn't get us to this instruction." So, but he doesn't want to do that.
That's what the defense had to say when he said, "Do you have any further argument?" They needed to say exactly what you just said. Judge, you sat there. I sat there. I don't know about you, Judge. I didn't see anything on the video. They couldn't tell me where Zeminski was. There's no way they could tell me that he pointed the gun up in any direction, much less at an angle towards Zeminski. We have no idea what movement is going on, Judge, or at least I don't, right? I guess you take that back upon yourself, and I watched it just as many times. There's no way this gets us to that instruction. They had to say it, and they just didn't. They let the prosecution finish, and if the judge gives you an opportunity to argue and counter a point, most of the time you should at least say something.
Unless it's
Not
so
always.
clear that you've won, and it wasn't there. Like the judge was still thinking about it.
Yeah, the second he says, "Show me again," that's when you know I've got to counter this. Why does he want to see it again? Two things. One, you either want to reinforce the fact that he knows he didn't see anything, or two, you have to understand that maybe he saw something that he didn't see before. And you have to point out, Judge, you're watching this over and over and over again. He's telling you what's happening, but he's testifying. That's what they did in court. They testified to the facts of this. There was no witness there. They could have called one. They could have called Zeminski, and they didn't do it. They didn't have to do it. They chose not to call Zeminski, and we have no foundation that he pointed a gun anywhere. And they just didn't do that. And I'm sure Fisi's been very sharp for much of his appearance during this trial, and I think that was a critical failure to not continue the argument.
Potentially.
So what I miss?
Apparently we missed
A lot.
a provocation instruction getting into the charges, and me one step from blackpilling again.
Yeah. The long story short is the provocation instruction is coming in. And at first, and this is the other thing, at first, DA Lunchbox, as Posobiec is calling him, is saying that their evidence for the provocation instruction is the picture, the blown up grainy picture. And then the judge's like, that just looks like a blob. The judge boomers his way through talking about how he saves screenshots of text messages, emails them to himself. And then when he tries to pull up the picture on the email and he blows it up, he can't see anything. He makes the argument that the defense was trying to lead him to yesterday. He figures it out on his own cell phone. And
he
so
had his
then,
own epiphany, right? He had his own epiphany moment, and they still couldn't capitalize on it.
yeah, and then the state goes, oh wait, well that's not our best evidence though. When they realize that they've just gotten hammered into submission on this, and then they're like, no, it's this other video. Then they show the other video. The judge's like, I don't see shit. And then they're like, whoa, it's the slowed down version and the zoomed in one, and you just need to go back, and all you have to do is say, Judge, that's the blurry thing you saw, just stopped. That's the exact same thing. It's from this video. That's what they're trying to show you. And they're just trying to fool you with motion that you see something, but you know you don't see anything because they picked the best possible frame and gave it to you, and you can't see it. And they just couldn't say that goddamn argument. And I'm so mad about it.
But you know what though? I don't think it would have been a winner though, because that's you're making a factual argument at that point in time. And my response to that, if I'm the prosecutor, would be that's for the jury to decide, right? If you're saying it doesn't show what it shows, we're making a factual argument, and that's why we have juries. The juries.
But the argument is really it can't show what it needs to show at the standard that it needs to show it at. Let's say jury comes back with a piece of paper, says, we found it on this photo, and this photo, and this photo. If you're the finder of law, you're the judge, you say, I can't look at that and actually say that people can come up with that. And you put it in the jury's hands, you're risking that every time. And I do think we got a preview for what a directed verdict motion would look like, for what a mistrial motion would look like. I think this judge is conservative, not politically, but in terms of how he treats a jury, and is going to be disinclined to do anything on the massive side of the scale that would get him in Newsweek again or anything like that. So I think you're getting a preview of, if in doubt, send to the jury from this judge. And that's not unusual for judges. I'm not
I agree. Richard, I agree with you that the judge doesn't want to go out on a limb. Very few judges ever want to go out on a limb. But at the same time, they have to make the argument so that if he denies it, they preserve the right to appeal. Because when you have a witness, the guy who is being charged with aggravated assault or attempted murder by shooting up at Gage Grosskreutz, and Gage admits on the stand that he did not fire at me until I pointed my weapon at him. Boom. On that charge of attempted murder, right away, that one has to be dismissed. That's how, at least get rid of that one. Knock them off one at a time. Knock that one off and let the judge say, no. A reasonable jury can still find that he was not acting in self-defense. And then with respect to that, that's appealable, that the appellate division will look at that and say, how the heck could any jury possibly come back with a
but that's what also makes provocation so important, right? Because he gets kicked into the different levels of, I need to exhaust every possible situation. And if you get that provocation finding, you're going to have trouble with even those obvious statements from the witness. So I mean, provocation was the linchpin. I think Nick said it right.
And to give a mild pushback to Nate, I agree that it could be construed as arguing facts, but when you've got the judge, and I don't know if you saw this, but the judge, they said, we showed you yesterday, right? We showed you the pictures yesterday, and the judge said, and I'm not even going to tell you what I thought about it. And he says those words, like, you're arguing facts at some point, but you're also arguing to and the judge said, when they said, he's like, you are asking me to add an instruction because the evidence clearly shows that this instruction is warranted and I don't see it. That's when you're like, no, you got to latch on to the judges. The judge already knew that this was wrong, and you got to go back. But the defense just went,
You're right. You're right. You're right.
And it's like,
And Binger has seen him do this 400 times, and that's why he knew he could push that Fifth Amendment thing, and the judge he'll fly off the handle.
Damn.
At the end of the day, he can always calm him down. He'll be like, "Don't worry, I'm sorry, it's all you're right." And then they'll just start talking, and then the judge will calm down, and then he'll come around to whatever Binger wants.
Kraus and Binger are playing good cop, bad cop.
But that gives Kyle a lot of
I don't know if
bites
it's
at the
good
apple.
cop, bad cop, because the defense is nowhere to be seen. That's the problem. It's like when the only person you're hearing from is the prosecutor, yeah, he can play that game. Where's the defense reinforcing their objections? Where's the defense, as you pointed out, when they give him the opportunity to make another statement of, you couldn't tell from the videos. Where are we getting this from? It doesn't make any sense. And
making bad arguments, right? Who was it that started to ask, is pointing a gun even a problem while they're having this out as part of the photo? It's like, what are you doing?
Richards, that was the other thing. Sheriff Easy actually was, he was I think he was kind of doing okay and rehabilitating what's going on. And Richards like, well, is it even a problem, Your Honor, for him to, is that actually provocation? Like raising it. Richards, are you going to, raising a rifle at someone absent some justifiable circumstance is provocation, probably. And yes, even if he points it at Zeminski and Rosenbaum sees it, Rosenbaum did threaten Kyle earlier, even though the state's like, we don't buy that argument. It's like, it doesn't matter if you buy the testimony or not, you're not the finder of fact. But even if he did make a threat, the jury has to determine that threat is still valid and that,
we feel your frustration, brother.
Sorry.
We feel it.
I know.
This defense fucks up. Yeah, we feel it.
And they fuck up at the critical parts. They're winning on the little stuff, and then the critical shit comes around. It's like, oh well.
They put the kid on the stand. They do this. They're doing all the bullshit. I don't know what's wrong. It's like they're trying to throw the case. I don't know what's going on.
I'm guessing it's over. It's they're panning around the courtroom right now and nothing's happening.
We keep seeing them, like, this is the frustrating thing, is we keep seeing them march down the field and move the ball down the field. And when it comes time to score, it's like all of a sudden they just start running stupid. They just basically go into some different mode and they just get stomped. And it's very frustrating.
So I'm just